Hi, this is Suzanne Bouchard, instructor with American Institute for Paralegal Studies. Discovery is such a big part of our advanced civil litigation course. In our class, we learned that modern discovery rules are intended to foster openness in the litigation process. The idea is that the more each party knows about each other's evidence and arguments, the more likely it is that the parties will ultimately resolve their dispute with themselves before the case even has to go to trial. The rules on mandatory disclosure ensure that the discovery process is efficient. Mandatory disclosure is governed by Rule 26 of the Federal Rules of Civil Procedure. Mandatory disclosure is the procedure that is automatically triggered early in a lawsuit. It requires parties to disclose to the opponent various types of information. There are three categories of disclosure that the parties must make when applicable. There's initial disclosure, disclosure of information on expert witnesses, and pre-trial disclosure. Initial disclosure is designed to give the parties a broad preliminary look at such information as potential witnesses, the existence of relevant documents, claimed damages, and any insurance information. The idea here is to eliminate the need for the parties to seek out this very basic sort of information through other discovery methods. The parties can focus their resources on using the information provided here through the initial disclosure to narrow the issues in their discovery requests. There's also mandatory disclosure of information on expert testimony. This is covered in Rule 26A2. Each party must disclose the identity of any witness it may use at trial to present expert testimony. Expert testimony can include anything from medical evidence to accident recreation and everything in between. Anytime a party intends to call someone as an expert in any field, they must disclose that information to the other side. Finally, there's pre-trial disclosure. Pre-trial disclosure has to be made at least 30 days prior to the trial. It's governed by Rule 26A3, and it basically gives each party a picture of what the opponent is going to present at trial, including witnesses, exhibits, portions of deposition transcripts, that sort of thing. As you can see, the modern rules of procedure are designed to eliminate surprises at trial. The rules governing disclosure and discovery are in place to facilitate settlement and avoid trial. If you know as much about your opponent's case prior to trial as possible, in theory, you'll be motivated to reach an out-of-court resolution of the case. This saves court resources, and most people think that's a pretty good thing. Now, if you're not currently a student at AIPS, you've been missing out on a lot of good classroom discussion about litigation. If you're interested in a career in the law, please visit our website at AIPS and join us in our next advanced litigation class.